Hello everyone, we have today top 10 questions about intellectual property in Ukraine. My name is Oleksandr Melnyk, I am head of corporate and M&A practice at Golaw, and we advise our clients on intellectual property. So let's get started. First question, which intellectual property assets should be protected? Basically, you should protect anything that creates value for your business and can be copied by competitors. This includes trademarks, software, design, text, photos, videos, databases, anything else. The key question is simple. If the asset is lost or copied, will the business lose money, clients, or competitive advantage? If the answer is yes, it should be legally protected. How exactly to protect? It is a separate question. There are different tools for different types of assets. When should you register a trademark? Ideally, you should register a trademark before launching the brand or the product. Not after the sales have started or distributions are involved and competitors are already watching, but before the commercial launch. Registration gives you an exclusive right to the brand and allows you to stop others from using identical or confusingly similar signs for similar goods or services. It also reduces the risk that a competitor, partner, or bad faith distributor registers your brand in their own name. For international businesses, one point is especially important. Trademarks rights are territorial, so the trademark should be protected in the countries where you already sell or plan to sell your products. Question number 3. Does the company actually own the rights to code, design, or content if it is paid? Not always. The fact that the company paid for the work does not automatically mean that all rights fully belong to the company. You need to look at who created the asset: an employee, individual contractor, external contractor, geek specialist, founder, consultant. The agreement with them must clearly state which economic IP rights are transferred to the company, to which asset, from what moment, in which territory, and whether the company can modify, sell, license, or transfer those assets to third parties. Without this, the company may discover that its key product does not legally belong to the business. How can you protect copyright in software, design, and content? Copyright arises automatically when the work is created, but for business it is not enough. You need to document who the author is, who ordered the work, who owned the economic rights, and how exactly the company can use the result. This requires employment agreements, contractor agreements, acceptance acts, and special IP clauses which directly state how and which property rights were transferred. It is also advisable to have a detailed description of the asset being transferred. State copyright registration is not always mandatory, but it can be useful as evidence in a dispute, especially when it comes to software, design, content, or commercially important product. The next question is, how can you protect a brand or product from being copied? So first, you of course need to understand what exactly is being copied. A name or a logo is protected by a trademark. The appearance of product may be protected by industrial design or copyright in the design. A technical solution may be protected by a patent or utility model. Commercial data, formulas, algorithms, or processes may be protected as trade secrets. After that, you need to record an infringement. Screenshots, correspondence, test purchases, marketplace pages, advertising, and so on. Then you choose the right response. A cease and desist letter, a complaint to a platform, an application to the relevant authority, or court action. Without properly secured rights, protection against copyright becomes much weaker and sometimes impossible. Question number 6. How can you fight counterfeit and unfair competition? Counterfeiting means fake or unlawful copies of goods created in violation of intellectual property rights. Unfair competition is broader. It may include copying the appearance of a product, unlawful using the reputation of a brand, misleading consumers, discrediting a competitor, or illegally using trade secrets. The right tool depends on the situation. For example, You can record your trademark in the customs register so the customs authorities can react to suspicious shipments entering Ukraine. Also, you can work with marketplaces and online platforms, send claims to sellers and importers, file unfair competition complaints with Anti-Monopoly Committee of Ukraine, or go to court to stop the infringement and claim damages. Next question: how should rights be transferred under license and franchise agreements? This is not just about saying we transfer the rights. The agreement must clearly define the asset: a trademark, software, design, know-how, database, technology, other IP asset. Then it must define the scope of rights. What exactly the other party is allowed to do with the asset: use it, modify it, sell it, copy, transfer it to somebody else, sublicense or commercialize it. The agreement should also define the territory, term, type of license, fees, quality control, liability and termination rules. In franchising, brand standards, trade secrets, training, marketing and control over the use of the business model are especially important. Next question: how does intellectual property affect the value of business? Sometimes intellectual property is the main asset of the business. For example, software, defense technology, a strong brand or unique product. For an investor, it is not enough that the company had a product, brand or technology. The key question is whether those assets legally belong to the company. If the rights are properly secured, intellectual property increases the value of business and makes it easier to raise investment, complete M&A, license the product, enter international markets, and so on. If the rights are not properly documented, this is a risk. No one wants to finance or invest in a company that does not actually own the key assets. That is why intellectual property is part of business capitalization. Question number 9. How should IP be structured before selling a business or raising investment? Okay, so before selling a business or raising an investment round, you should carry out sort of IP cleanup. First, prepare a list of all IP assets, trademark, software, design, content, whatever. Second, check who legally owns the rights and trace the full chain of the transfer of ownership to these rights. Third, close all the gaps in agreements with founders, employers, individuals, and other people who developed this intellectual property. Then, review registration, licenses, encumbrances, open source components, disputes, and claims, and arrange transfer or confirmation of the rights transfer where they are missing. An investor is not buying an idea, they are buying a legally controlled asset. And the final question is: how should IP be checked when buying a business? When you are buying a business, a comprehensive legal due diligence is usually carried out, and it should include an IP review. In this part, you check which IP assets the company has, whether the registrations are valid, who owns the rights, and whether agreements with authors and developers, employers, were properly documented. You should also review licenses, franchise agreements, restrictions on use, litigation, claims, pledges, open source risks, domains, trade secrets, and access to key data. The purpose of the review is to understand whether the business actually owns what it is selling. So, if the company's main asset is a brand, technology, or software, IP due diligence can directly affect the price, the transaction structure, and the seller's warranties. If this video was useful for you, please follow us on Facebook, Instagram, TikTok, YouTube, and Telegram. And don't forget to like this video and comment, because there is much more interesting to come.